Hello and welcome to the Rogers Brief for April 26th, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. Got some interesting stories to cover this week, including a few updates from stories we've been looking at. Among them, the Zameer case out of Toronto, the unfortunate killing of a police officer there, which led to a jury trial and an acquittal. Have some updates on that. The Justice Minister situation in Nova Scotia, an update there. We have a new Justice Minister. And SiRT, we have a new SiRT Director as well, who's the same as the old SiRT Directors. The interim director has been named to a permanent or to a 5-year term at least. So we're going to get into those and a few other cases. Going to look down to the States as well, to the Trump situation before this U.S. Supreme Court. I'm not going to be looking at the Stormy Daniels case, although I'll make a brief mention of it. And the other is the Harvey Weinstein appeal, New York State appeal, which was successful. And I want to talk about in those two cases, the Trump and the Harvey Weinstein situations, how either one of those might play out if a similar situation unfolded in Canada. Okay, so we'll get to all that. This week, just to mention a quick political thing, we had Conservative leader Pierre Poilievre in Breton in eastern Nova Scotia the last couple of days, Wednesday and Thursday. Huge reception everywhere, hundreds of people at these events. In Port Hawkesbury, I know he was at the Port Hawkesbury paper, the mill there. Very warmly received. Lots of people happy to see him. He was at the Rock Center, a place for adults with disabilities with employment prospects, and they have a store there. Very well received. Went down to Sydney to Protocase. Same thing. Well received all over the place. Had a big rally in Port Hawkesbury Wednesday and had to be moved to a larger room. Lots of smiles, people of all ages, new people to the party, lots of things like that. So everything was going well. So what does the national media say about it all? Hey, isn't it terrible that he stopped at the Nova Scotia New Brunswick border and met with some protesters and trying to tie them all into these Diagolon groups, saying that these were, dangerous people and they're associated with hate groups. What was the evidence for it? These were anti-carbon tax protesters that were parked there at the border protesting, giving the message, anti-carbon tax message. So on his way to Nova Scotia from PEI through New Brunswick, Poilievre stops just to chat with them. And so the media says, well, he's supporting this, Diagolon anti-government organization. Okay, what's the evidence for this? Two things, apparently. One, if you see the video, you'll see that one of the trailers has, writing all up and down the wall. At the bottom of the door, there's a little symbol that is a symbol that's associated with this Diagolon group. None of these people involved were leaders or involved in it in any way, except one person. It says interacted with some leaders of Diagolon on social media. All right, well, what does that mean? Does that mean that they retweeted or they tried to comment on some posts or what? Pretty small stuff, but of course gets blown out of proportion by people who have this sort of reflexive view or wish to promote negativity about anything that's a conservative view. So anyway, it was a great visit otherwise, and that'll be the lasting impression. Lots of people were very happy to meet the future Prime Minister. All right, so enough of that. We'll get to cases and situations. This is Zameer case out of Toronto. We'll be talking more about this Sunday night. Because so last week we talked about how he was acquitted by the jury, and that wasn't unexpected. Sunday night we got a chance to talk about it after the jury verdict was reached. Last week on the Rogers Brief, the jury was out. I had expected that they were going to find him not guilty, but then you never know, but that's what they did. And And there were some questions too that I know on Law Twitter, there was some lawyers concerned about some of the questions that the jury had for the judge. Not unusual during the course of deliberations for the jury to send some questions out, maybe something they didn't quite understand. The judge explained in their instructions on the law. Anyway, so he was found not guilty. He was acquitted. The judge apologized to him from the bench. And so what does the chief of police of Toronto say? This Chief Myron Demkiw, Demkiw. Well, he had wished for a different outcome. I'm not sure why. Well, he was there with the widow. Of course, Zameer, every time he no expressions of bitterness or anything like this. It was all, he was concerned about the officer's children. It was a terrible accident, and he's kids himself, so that was where his mind was. The chief of police was there with the widow of the officer, and saying they wished for a different outcome. Respect the jury. He's, said sort of lip service to respecting the jury and all these things, but he wanted a different outcome. And then they have a provision apparently in Toronto where if a judge basically calls into question the integrity of officers, as this judge certainly did, telling the jury, listen, if 3 officers say a version of events which we know is untrue, and they say it in the same way, you might conclude that they have colluded on that answer. Okay, which was clearly the case here. Video showed the officer was laying on the ground when he was run over. All 3 officers that were there with him said he had been standing up and fell over the hood of the car. All right. So the chief says, okay, chief of police says, yes, okay, there's an automatic review when something like this happens, so we've done that. But at the same time, we're going to also order a review of how plainclothes operations take place, what the protocols might be, and, to make sure this kind of mistake, whatever, doesn't happen again. I think he's hoping that there'll be 2 reviews come back at the same time, one of which says, when you're in plain clothes as a police officer, there has to be, more clarity as when you reveal yourself to somebody, as these officers claimed to have done to Zameer. Zameer denied it, and all evidence pointed to the likelihood that they didn't say anything to him. So why would you hope for a conviction in this case if you're the police? I mean, if the person was convicted, that means that you have somebody out there who is trying to deliberately run over police officers. Their version of events was, he was told were police officers, and instead of saying, oh, good, okay, I thought you guys were coming to attack me, but you're just police officers, great, everyone have a good night, he hit the gas and ran them over. Well, that seems much, much worse to have somebody like that in existence. Why would you hope for that? Not sure. Okay, so weird psychology going on there. All right, speaking of, and the Crown, of course, supported that case the whole way through to conviction, to the end of the trial and acquittal, even in the face of the judge saying, are you serious? You're still pursuing this theory, even in the face of this video evidence to the contrary. And the Crown did. Well, not exactly the same, but we have this situation now in Halifax. News this week from the Halifax Shopping Centre, which seems to be a frequent location of criminal offenses. This young guy, 16-year-old victim, Ahmad Mahar Al-Marak, Syrian refugee, very sad story, that came from Syria as a refugee to Canada. His family was, they weren't doing great, but they were getting along, and anyway, he was attacked and killed, so we're told, on Monday by two 14-year-olds from Lower Sackville were arrested a couple of days later. They made their first court appearance, and Terry Nickerson, Crown prosecutor, tells Judge Duffy right away that the Crown will be seeking adult sentences for these 2 14-year-olds. Not dissimilar to the stabbing at C.P. Allen, where it was almost immediate that the Crown says we're going to be seeking adult sentences for these two 14-year-olds. Now, maybe they know something about the particulars of the offense or the 14-year-olds that would justify that, but it seems unlikely, all right? So you can't be charged with a crime until you're 12. Youth criminal justice goes until you're 18. So this is at the lower end of the youth criminal justice age range. So already difficult to justify seeking an adult sentence. Not that they've been convicted. And it just seems that the Crown is succumbing to public pressure and or their sense of public pressure to make that kind of a statement right away. To me, there's no way they could have enough information on the maturity levels, backgrounds, all of these things of these 14-year-olds. Normally, if you're going to sentence somebody to a serious offense and to potential jail time, the court will order a pre-sentence report, which is, can take a month or two to prepare. Probation officer speaks to people that know the offender. All of those things comes back into a long form essay on the person, a little biography, and they, then make a determination as to appropriate sentencing. Well, here we have people that were arrested, and basically the next day, the Crown is saying they're going to seek an adult sentence, so seems very premature. More to come. Couple of new appointments in Nova Scotia this week. So the next story is we have a new Justice Minister, and this is Barbara Adams. I saw a note last Friday when the former minister, Brad Johns, stepped down that Tim Hallman, the Environment Minister, was going to be appointed, but in fact, it was not that. It's Barbara Adams, currently the Minister of Seniors in long-term care in Nova Scotia. Well-spoken minister in that portfolio, not a lawyer or anybody involved in the justice system otherwise, but seems like it will be an improvement. Her initial comments related to domestic violence, which was the reason in a sense why Brad Johns stepped down. By the way, a comment on that, just when Brad Johns stepped down, he did say that the reason he stepped down was to maintain faith in the system. So now whether that was genuine or not, it was a good thing to say on his part, and I think between the fact that he resigned and sort of enhanced the concept of cabinet responsibility, and those comments will, I think, do him credit. So I think I have to be fair to Brad Johns in that respect, it was a good thing for him to say. Now, is there going to be any actual change in policy or direction in the department? That remains to be seen. There was nothing other than, her comments saying she was reaching out to organizations and such to express how important domestic violence policy was to the government. There's nothing concrete in terms of what that change might be, whether they're going to follow the Mass Casualty Commission recommendations on the subject or what. So we'll watch for those kind of signs in the weeks to come. Another new appointment in Nova Scotia is the head of the Serious Incident Response Team, the SiRT. This is the police watchdog that anytime the police are involved or alleged to be involved in a violent incident, then they are investigated by SiRT. And it had been initially it was led by Ron McDonald, former Crown prosecutor. Then it was Felix Cacchione, former Justice of the Supreme Court. For a while it was led on an interim basis by Judge Pat Duncan. Then it was Alonzo Wright, who was a Crown prosecutor, then named a judge very soon after taking on the SiRT position. And so on an interim basis, Aaron Noss, who had been involved in SiRT since the beginning, but as staff lawyer, I guess, in the organization, took over as interim director, has now been appointed as the full-time director, a 5-year position. So Aaron Noss is somebody I knew close to 20 years ago, she articled a year behind me at what was then Cox Hansen O'Reilly Matheson, now Cox and Palmer, one of the big Atlantic regional law firms, and was well regarded then. She was seen as somebody, a very competent lawyer, promising in terms of where she might go in her career. But after a couple of years, left Cox Hansen and went to the province. And I haven't really kept up with her since then, but seems to have done well and has done okay work in this position too as interim director. At least been trying to get the Glen Assoon case, get somebody to look at the Glen Assoon case, the wrongful conviction there, and the police activity that led to the wrongful conviction and the extended wrongful stay in prison of Glen Assoon. She did also refer the Onslow Belmont shooting onto the Ontario equivalent of SiRT. They came back with a conclusion that we probably don't like, but that's at least that she found somebody to look at it and kept on that. So let's see how she does in the position. Not a particularly high profile hiring. A lot of the time, you might expect in this position a former judge. And the benefit, in a sense, of having a former judge is that the decisions of SiRT then sort of take on the weight of a judicial decision, even though the judge is no longer in the position because of their career and their experience. The decision gets the sort of gravitas that came with having Justice Cacchione or Judge Duncan in the position. But anyway, we'll see how this goes, and if Aaron Noss is able to maintain or enhance the credibility of the organization. All right, so next I want to move to some Supreme Court news, and just by way of comparison from the Canadian and United States Supreme Court deliberations. So Supreme Court of Canada, the news this week you may have missed is that the Supreme Court Chief Justice Wagner was asked about the flag. The Supreme Court has a flag. Why does the Supreme Court have a flag? Well, he's described it as being significant because there's the three branches of government: the executive, the legislative, and the judicial. And that was sort of to emphasize the separation of powers. Like, all right. Does anybody know what the other two flags look like? We don't, but the Supreme Court has a flag. So that caused a little stir in sort of law circles. Not much of one. But the other one was the big case they had this week, which wasn't that big after all. Military judge. The question was, in the military judicial system, is somebody who served in the military able to be a judge in the military system? And the suggestion was by the plaintiff, the applicant, was that no, because they're too entwined in the culture of the military in order to be impartial. Supreme Court said, I think 7-1 or 6-1. No, that's fine. They're still a judge. They can do the job. Well, from that sort of almost obvious kind of a decision, low level, to the U.S. Supreme Court trying to figure out whether a president can be charged with a crime. I mean, that's a very fundamental thing in a way, and not explicitly covered in the U.S. Constitution. So there's some questions. Now, the Supreme Court held hearings yesterday for 2.5 hours. So that's doesn't seem like a long time to deliberate or to debate such a big issue, but there's extensive briefs. Lots of work goes into a Supreme Court of the United States hearing, same in Canada too, prior to the hearing itself. Nobody's going in cold. They've read everything. So the presidential immunity question mostly comes into place because of the January 6th rioting and whether President Trump encouraged that and whether that's criminal in nature. And also pressuring other jurisdictions on election results from the 2020 election. Was that pressure? Was it undue pressure? Was it criminal pressure? What is that? And can a president be charged? Because presidents are immune from civil liability while they are presidents. So Trump is trying to argue that he is immune from any criminal liability. It seems unlikely. The questions that the panel of 9 Supreme Court justices were asking focused mostly on the question of what is a personal act or private act versus official duties, and where do you draw the line, and can you be in the course of doing something official, appointing an ambassador, for example, but accept a bribe in order to appoint that ambassador and thus draw personal, private criminal liability. So those are some open questions that the court's considering. But they seem fairly clear on that there is some potential for personal criminal liability. So, it amounts to, in a way, well, would you or could you be doing this if you weren't the president? Of course, if you're not the president, you don't appoint ambassadors or send drone strikes or many other things that a president does in the course of their duties. But if you're assaulting somebody in a meeting, if you steal from somebody, you could break somebody's possessions. There's lots of things that you can do as an individual that don't depend on you being president, or aren't, the relevance of you being president isn't really there. If you punch somebody in the face and you're the president, well, you've still punched somebody in the face. There's no official duties that are going to excuse that. So in a sense, those things are fairly clear, but where exactly is the line? What I expect is going to happen is that the court is going to provide some, they're not going to decide here's the standard for where the line is between private and official, and by the way, we now apply that analysis to the facts of the election interference allegations, the September 6th, inciting a riot allegations. The Supreme Court is not going to do that. They'll come out with guidelines as to what and how, what is private, what is official, and how you make that distinction for future instances. And then they'll send it down to the lower courts to do the fact-finding and detailed analysis on each individual particular situation. So that's likely to mean that there'll be a Supreme Court of U.S. Supreme Court decision probably in the next couple of months, and then maybe schedule a trial. Seems unlikely that will all happen before this fall's presidential election. The one case that is going on now, that's been going for the last couple of weeks in New York on the Stormy Daniels thing, boy, that's not going well for the prosecution. Not looking good. Maybe going into a presidential election with an acquitted former president, and some probably strong Supreme Court language suggesting that much of what he is accused of doing while in office is not going to be subject to criminal prosecution. That's my sense of it. Reading through some of the analysis from the New York Times and The Economist and others seem to say that the bench, there's some conservative justices on the bench, may be looking at a 5-4 decision, a split decision, but that's all you need. You need 5 votes in favor. Okay, last thing I want to talk about is Harvey Weinstein. Miramax, former head of Miramax Studios, maker of many movies, lots of movies that a person seen. People remember this now. This was really the lead case in the Me Too movement from a few years back when Weinstein was convicted. He was convicted in both New York and Los Angeles. Well, this week he was acquitted of the New York convictions. Why? Well, sexual assault cases, certainly in Canada, there's severe restrictions on what kind of evidence the Crown is allowed to bring in terms of, hey, that's a bad guy. You have the allegations from whatever the allegations are, that incident. You're not allowed to go back and say, well, here are these other 5 or 6 women that said, they weren't very comfortable with him either, or, he assaulted this woman 5 years ago. You're not allowed to bring that kind of evidence into a trial because it's seen as prejudicial to the defendant. It's, the risk is that it's going to make a jury think, well, this is a bad guy, so he's more likely to have done this, even if the evidence isn't particularly strong in support of the Crown case. So what happened in New York was that there were 3 such witnesses who came in that had nothing to say about the core allegations, and this was controversial at the time. There was 3 witnesses that came in just talking about the bad character, Harvey Weinstein's bad character, other incidents where, they were involved. And so the conclusion the jury was supposed to reach is, well, if he did it then, he probably did it this time too. And so he was acquitted. It took a while, but he was. So the question is going to be, is there going to be a retrial in New York? Will the witnesses want to testify again these many years later? And all that. One witness apparently has said that she is willing to testify again. It may, in a sense, be a moot point because Weinstein has a 16-year jail sentence to serve, sort of a backup jail sentence to serve in California. He was convicted in LA as well of sexual assault. And strangely, if you're a Canadian, because the law is the same in BC as it is in Manitoba and Ontario and Nova Scotia and all over, a little bit of an adjustment in Quebec with their civil code, but the criminal code is the same across the country, which is different in the States. So in California, they give wider latitude to allowing bad character evidence to come in. The other downside of bringing in bad character evidence is it extends the length of trials and uses up judicial resources and court resources. So there's a number of reasons or justifications for the restriction. But apparently in California, this is what I've been reading, is they're not so much like that. Because what happened in the LA case was the jury was able to hear about the New York case. And, he's just been convicted there by a jury. So here, California jury, he's already convicted. He's a bad guy. Why don't you just convict him too? That's less of a problem apparently in California. And so the legal experts there seem confident that the LA conviction is going to stay, although he has appealed that as well on basically the same basis. So we'll watch for that as well. So it's much different in Canada. You wouldn't be able to bring this kind of evidence against a high profile, low profile, whatever kind of an offender to try to secure a conviction. So an interesting week through some of the changes in Nova Scotia with high profile positions. Some interesting cases out of the U.S. with, I thought, not connections to Canada, but distinctions from the way we would handle those things in Canada, and be watching for the progress of these 2 14-year-olds in Halifax, and looks like an overeager Crown position on that one as well. So we'll keep an eye out. So, all right, thank you everybody for watching, and thanks for listening. We'll see you next time.